Good evening. We are here to discuss an interesting topic today, which has the potential of changing the litigation or IP litigation landscape in terms of forums where these litigations will be fought or contested for various intellectual property laws, as well as other laws. And I'm very fortunate that we have with us Mr. G.R. Raghavender to discuss this. Now, before I tell you more about Mr. Raghavender, I want to kind of talk about a little quickly about the new law that we're discussing. This is it's a long name. It's the Tribunals Reform, Rationalisation, and Conditions of Services Ordinance of 2021, which was promulgated by presidential order on April 4th, 2021. Now, in effect, what the ordinance seeks to establish or achieve is dissolve or transfer the functions of certain key appellate tribunals to the commercial courts and to the high courts, one, and two, set out terms and conditions and rules which would govern the appointment of by the central government of members of the existing tribunals and their terms of service, etc., and terms of office. Now, this is all within the construct of the Finance Act by way of backdrop, the Finance Act 2017, which had carried out amendments to the tribunal framework across multiple laws. This law seeks to amend those earlier changes. Now, to introduce our panelists and our guest, actually the only guest that I'm going to be speaking to today is Mr. G.R. Raghavender, who is a civil servant, a joint secretary with the Department of Justice, Ministry of Law and Justice, the Government of India. But I know Mr. Raghavender as somebody who has had a wonderful and most positive impact and a very determinative impact on intellectual property policy development and law development in the country. He was earlier the Registrar of Copyrights, the Indian Copyright Office, and he oversaw the introduction of massive amendments in 2012 to the Copyright Act and also the introduction of the copyright rules. He started the online registration of copyrights in India, along with the payment gateway and digitization of records, the Copyright Office. I know that wasn't an easy job, and gave also the Copyright Office its new logo, look, and branding avatar that we know the Copyright Office today. I have to clarify that Mr. Raghavender today joins us in his personal capacity, not as a member of the government, not as a government servant, and his views are his personal views and they don't reflect either the position or the views of the government of India. So that's a caveat that is going to apply across the board for our entire discussion. But the importance of Mr. Raghavender's views are because of his massive experience and backdrop with intellectual property laws. It'll be interesting to have his views on what the impact will be on intellectual property jurisprudence by this change. So I want to welcome you, Mr. Raghavender. Thank you so much for taking out time. I know it's a very, very busy schedule for you, particularly now we are going back to e-courts and all sorts of massive expansions to bring justice to people from a virtual perspective. And I know you must be in the thick of it. But thank you so much again for joining us. So I had a couple of questions.
Thank you, Ameet Datta, and also Lohita Sujit and her team inviting me here. Thanks a lot.
Correct. And I also want to thank Lohita Sujit of the Motion Pictures Association for giving us an opportunity to host this on Creative First. This is going to be a video available on Creative First, so a lot more people can look at it later. On the tribunals, Mr. Raghavender, in your own words, could you briefly describe what the ordinance is and what it aims to achieve?
First of all, good afternoon, everyone. Namaskar. And I would like to congratulate Creative First and Lohita and her team, and also you, Amit, selecting very appropriate topic, that is Tribunal Reforms, Rationalization, and the Conditions of Service Ordinance 2021 discussion. You know, at the outset, I would like to say that this policy initiative of government of India is going to bring a disruption the way the litigation, especially the intellectual property litigation, going to be treated. And I'm in full support of this because I've seen the delays happening and various administrative problems, legal problems, and it satisfies not only the government and administrative policy reforms and the mindset, also the judicial mindset. So I'll just tell you what are the comments of Supreme Court, what are the comments, what are the problems and faced in the High Court. As a senior lawyer, senior IP lawyer with more than 20 years experience, you know that in the legal sector what's happening. Coming back to this tribunal reforms, rationalization of conditions of service ordinance 2021, this came into force from 4th April 2021. And originally, you may be aware, and the other people who are watching this may be aware, that on February 13, during the budget session of Parliament, a bill was introduced by government, Tribunal Reforms, Rationalization of Conditions of Service Bill 2021. But unfortunately, during the thick of various important legislative business, Lok Sabha could not take this and pass this bill. Since it is very essential and imperative to get this transformed into a law, so government used exercising, and of course the President of India exercising his ordinance issuing powers, with the cabinet approval, this decision has been taken to issue ordinance to make a law. So as you know that the moment the next parliament session comes, maybe in the monsoon session, a bill has to be introduced again, reintroduced in the parliament, and both houses have to pass, and otherwise ordinance will cease to exist. And if the next session of parliament doesn't pass this bill and convert this into act with the honorable president's assent, there's a problem of reissuing the ordinance once the monsoon session is over. So hopefully that won't happen because it's a very, very important initiative. There has been on the table this issue of too much tribunalization happening. Too much tribunal. Of course, tribunals are required, but it has overreached its requirement. That's what Supreme Court time and again said, that over tribunalization has reduced its own powers. And it says that Supreme Court has become a mere appellant body for the tribunals, instead of doing its constitutional duty of examining and giving justice on this substantial question of law issues. Respected Attorney General Mr. Venugopal always says that Supreme Court should be set aside and left to deal with only substantial question of law. Even it is dealing with the appeal cases of divorce cases. So unfortunate that this has been created in our legal system now. There is around 62,000 cases pending in the Supreme Court, despite number of judges posts have been increased recently to 33. Still, pendency is increasing. Reason why pendency is increasing, there is already another argument, and matter is sub judice in the Vasant Kumar case. It's about creation of regional court of appeals of the Supreme Court in North, South, etc., where these courts, the divisions of Supreme Court, will take into these kind of appeal, and the main Supreme Court in Delhi with the left with the issues like only substantial issue of law. None of the appeal will go to Supreme Court, and all these appeals under SLP file under Article 136 will end up in these Court of Appeals. So since the matter is sub judice, Supreme Court had to constitute a larger bench to look into this constitutional issue. And now government thought that let this burden of Supreme Court be reduced because as you know, Ameet, that once tribunalization started, so the Administrative Reform Committee in 1967 recommended that tribunals may be established, tribunals may be constituted in suitable areas where a cheap, more accessible justice can be done, reducing the burden of high courts. But it's a false decision that only the high court burden can be reduced by setting up tribunals. So the very word tribunal, it's not defined anywhere, as you are aware. If you see the Constitution, there is a mention of tribunal, but it's not defined. So what exactly is tribunal supposed to do? So that is the big question. So now we're all worried about abolishment of 9 tribunals. And since we're all from the intellectual property sector, we're all worried about that we used to run to IPAB, or we used to run earlier before Finance Act 2007 replaced Copyright Board with the IPAB in the Copyright Act. So now we don't have either Copyright Board, which was made permanent from the temporary kind of board in 2012 Copyright Amendment, and then 2017 Finance Act introduced the reforms in tribunals and the service conditions, the Finance Act 2007, which has been amended in this Tribunal Reforms Rationalisation of Conditions of Service Ordinance. So what is a tribunal? So in Durga Shankar Mehta versus Raghuraj Singh, Supreme Court defines, it says, tribunal is not an ordinary court in the sense. It's not an ordinary court, it says. So, but it's an adjudicating body constituted by the state, and it is vested with some judicial functions as distinguished from the normal administrative and executive functions. So you know that as a senior lawyer, these tribunals are not supposed to follow the normal way which High Court or any other court functions. They're not to bother CPC procedures, not to bother the provisions of Indian Evidence Act, but slowly, instead of following this, without naming a couple of chairmen who were known to me of these tribunals or a former Copyright Board, that they said that lawyers bind us to follow the CPC provisions. They bind us to follow Indian Evidence Act provisions. So these tribunals, instead of imparting instant, speedy, cost-effective justice, because they have been drawn into this rigmarole of CPC provisions, Evidence Act provisions, delay is happening. The very idea to set up, constitute a tribunal is to reduce the time taken for the access to justice. dispensing easy and faster, speedy justice, cost-effective justice. That's not happening. Because, and not to blame only the lawyers, even they themselves take that discretion of following it. Totally blaming lawyers is not fair, but it is a 50-50 responsibility converting tribunals into nominal court functioning. This happened. This led to a kind of delay led to the clogging led to pendency, and there is no difference between the normal court system or a special court or high court. The same kind of procedures happening and all this happening. So that is wonder. So what these tribunals supposed to do? They simply follow the principles of natural justice, and they provide speedy, because they should have developed their own system, mechanism to do this. For that, the chairman is supposed to frame rules. That most of the tribunals have not done, failed to do that. How this court has to take, for example, Copyright Board. Copyright Board has to act as per the provisions of the Copyright Act, whether the Section 6 or 11 or compulsory license provisions or other license provisions, and then Section 78 and blah blah, drawing powers and all that, and follow the mechanism of explain how to execute this in the copyright rules. Apart from that, instead of following CPC and Evidence Act, they never frame its own rules. Just like High Court, each High Court has its own rules, High Court rules. Each tribunal should come out. But that's what Act empowers them, but never exercise, and they got into this black hole of CPC and CRPC, or sometimes our Evidence Act, and that became the big issue. And if that is one big issue which was delaying, another important thing is, before going to tribunalization, I mentioned, one more policy reform took place. 42nd Constitutional Amendment in 1976, if you remember. Two new articles were introduced. Article 323A of the Constitution, or Article 323B of Constitution, which took away the power of the High Court, the appellant power of High Court over the tribunals in its jurisdiction, and legislature took away those powers, and Parliament took away that authority, constitute tribunals. And whether it is administrative tribunal, other tribunal, that power has been given to them. So prior to this, tribunals under the control of concerned High Court, maybe the Delhi High Court or Mumbai High Court, orders were from these tribunals to be filed before these high courts for appeal. So that ended. An entire new disruption was introduced, that once the tribunal passes order, let's say the IPAB passes order, even recent Supreme Court judgment said, and any order of this tribunal or IPAB can be challenged directly in the Supreme Court under SLP Article 136. You need not go to High Court. But because judicial review of these tribunal orders, IPAB orders, such that no appeal, no review, no revision, no reference against tribunal orders. Only one thing you can do, you can go to Supreme Court filing SLP under Article 136. But the intelligent lawyers changed this method, and High Court judges also accepted the present scenario of delaying the justice to this industry. Let us say the entertainment industry, of content industry like film industry issues or music industry issues, or the broadcasting industry issues, or various patent issues of the pharma industry, or various brand related issues of trademark, instead of getting challenged once IPAB passes its order, if that is not palatable to the other party, losing party, instead of going to Supreme Court, already Supreme Court started expressing its displeasure in various judgments. Legislation has made as appellant body instead of constitutional body, questioning the,
Yes.
dealing with the question of specific law. Here, High Court started dealing with. Why people go to High Court? There are reasons for that. Because appeal allowed over tribunal order, just like we were discussing the IPAB order, because let us say, for example, in a hypothetical situation, IPAB failed to exercise its jurisdiction or acted without any jurisdiction while passing the orders, or orders are modified, or orders are ultra vires, or orders are arbitrary, or no principle of natural justice followed, or error is just very error on the face of the fact or record, whatever you lawyers say. And all these reasons made people rush to High Court, not because Supreme Court delay happens. Is also Supreme Court is very expensive.
Yeah.
Not everyone can afford, even
Yeah.
though industry can afford. It's very time consuming and very expensive. High Court very easy. Mumbai people go to Mumbai. Delhi people go to Delhi. Chennai people go to Madras. The High Court is in their pockets. Whereas Supreme Court, you have to travel long. This is for this reason, High Courts got clogged with that.
I take your point.
So this is the mixture. Let me explain two more reasons why this policy decision taken by the government to remove these 9 bodies, tribunals. Let me complete and then we'll discuss various other things. The main thing is, already told you, rampant tribunalization happened. This was worrying not only the executive, also judiciary. Especially, I told you, Supreme Court n number of times that I'm ad nauseum, I'm repeating this, that you made Supreme Court an appellate body, not a constitutional body. So, and the 42nd Amendment also did one injustice to High Court. It sidestepped the powers of High Court by allowing the litigants to file SLP directly in Supreme. By making Supreme Court appellate body, if that was a mistake, sidestepping a High Court also a mistake. But lawyer found some other way, which I enumerated before, whether orders are ultra vires, or lack of jurisdiction, or overacting jurisdiction, or error in face of law, and all that, fact and all that, ultra vires or maybe. But Supreme Court became appellate body, High Court got sidestepped, and reason why sidestepped to reduce the pendency of High Court, that is totally wrong, misconception. I tell you why. There are 3 main institutional concerns raised by either by executive or judiciary once tribunalization started. Number 1, tribunals do not enjoy the same constitutional position of High Courts. High Courts are constitutional bodies. As per Article 216 to 231, High Court draw powers, except the recently 42nd Amendment articles to 323A or 323. What powers tribunals have? No, they are nothing. They're neither courts nor constitutional bodies.
Correct.
So tribunals cannot be compared with the High Courts. And then a question comes, the very questions raised by Supreme Court in recently concluded case, that Matthew case by Supreme Court, and Madras Bar Association case again.
Yes.
How this search come selection committee to be appointed, how many judges should be there. When the government said one judge is enough, remaining were with full of government secretaries. It said there is an imbalance in that. Supreme Court in Roger Matthew case recently on NCLT
Yes.
selection comes
Correct.
search comes selection committee case said no, there should be two judges and two or three secretaries. Then there is a balance. Why this balance is needed? Because there is a severe criticism on tribunalization, taking away the powers of the courts, setting up so many tribunals, because tribunals take away the powers of high courts.
Yes.
And independence of judiciary is compromised. Who appoints high court judges? It is the Supreme Court collegium.
Yes.
The Chief Justice selects of the particular high court, its own high court collegium selects the names, send it to Supreme Court collegium. They nominate the name, then government appoints after whatever the procedure, administrative procedure they have to follow. And then there are first a case of judges case, second judges case decisions are there. That once the government rejects this and Supreme Court supports the same decision, government can't reject it. It has to appoint a judge. But this kind of independence of judiciary appointment is there. The totally executive. There is a criticism that most of the tribunals are filled with civil servant, not people with having judicial knowledge. You maybe call them, sometimes you call them subject experts, but calling them subject experts misnomer, because they don't have, they can't be compared with the subject expert like in IPR, like Ameet Datta. Simply pushing some files and making some reforms without basic grilling in the IPR law, whether it is in national legislation or international legislation, that knowledge, one can't claim expertise over that simply sitting in a seat for a couple of years. So this is what happening, and even government was feeling that this is may not be a good policy. They wanted to change this following this amendments to Finance Act 2017 by introducing this Tribunal Reforms Rationalisation Bill. And second reason I tell you, and tribunals are not as accessible as high courts. By removing these 9 tribunals, you take IPAB. Where is the headquarters of IPAB? Chennai. Bloody all the way from Delhi, you have to book a flight and go there. From Mumbai, they have to go there. From Guwahati, they go to there. There may be a bench in Delhi, but when that bench functions, no one knows.
Correct.
IPAB bench. Okay. And these are the problems. If these are the problems, and appointing the chairman of the IPAB, and everyone is not Justice Prabha Sridevan. With the experience and knowledge and that grilling in the IP law. Everyone is not Justice Prabha Sridevan. Also, another advantage of Prabha Sridevan, she is from Chennai. People are not ready to go to Chennai and sit there because there's a problem of displacing from their place, Delhi or Mumbai, those retired judges, they should get an accommodation, and they're not getting all the facilities there. That is another reason. Now, if you find a right person like Justice Prabha Sridevan, that honorable judge is not ready to go there unless you give all the facilities. Again, question comes the members. Members again. I know couple of, without taking the names, couple of people who were selected as members, they couldn't go and join because of these reasons from Delhi. Had it been there in Delhi, they would have jolly well joined as a member. But many people say that, these technical members of the IPAB added value to the decisions. But once a value has been given to that, when the matter goes to High Court, and High Court is to scrap that order and dictate its own order, the only thing is it trained those judges sitting there in IP law. That is the only thing. Or and develop them from the district judge point of view. in IP law, groom them, and when they go to High Court, put them in the commercial division, expose them to higher insights, so that they are trained there. They are trained there, these High Court judges, for further promotion to Supreme Court, where
So is
more
it? I think
complicated law comes there. Then because
you've hit a very
tribunal members simply end their life, they can't go to Supreme Court.
you've hit
This
a
is
very
another
important
reason for
you've hit a
removing this, to making them a training place for judges, so that this single judge commercial bench in High Court. Then I told about accessibility. Instead of one IPAB board or one bench, you have 25 High Courts to reach from different places. And then I just tell two more points and then conclude, to allow you to discuss on these things and go for other questions. Appeal against tribunal, already told you, goes to Supreme Court, not to High Court. And this is other problem. And this is increasing Supreme Court pendency in the Supreme Court. This government wants to avoid, and not to make it, and accepting Supreme Court's observations and not to make it an appellate court. And third and final is already mentioned, High Court have to be a training ground for these judges who get promoted to Supreme Court. If they are deprived of this and directly appeal goes to Supreme Court, they are not exposed to these cases. They are totally sidestepped and also deprived. It's an injustice to High Court judges not to allow them and not to get exposure, not to get insights into this kind of complicated IPR case, because under the Commercial Court Act, if you see the definition of the Commercial Code, Section 2, subsection 1C,
Right.
there are 22 categories.
Yes.
Varieties of commercial dispute. In this, all IP, whether patent, trademark, even trade secret also, forget about design, copyright, and plant variety, and semiconductor layout design, and other biodiversity cases. Here, you are depriving them of these issues, because when directly go there, unless and until an intelligent lawyer like you takes some issues that it's not as per the fact of the law, or IPAB is not exercise jurisdiction, or exercise its rights beyond jurisdiction, or ultra vires, something you have to write and then go to High Court. Otherwise, High Court is deprived.
Right.
So these are the reasons I say I fully support abolishing this. Appointments also getting delayed. So many years these people, these IPAB was headless or memberless. What is the fun having that when people are not ready to go and sit there and do the work? So best is there are 25 High Courts under the Commercial Court Act, and I'll come to other advantages while answering the other questions. Yeah.
In fact, you've really very nicely covered, Mr. Raghavender, what the reasons were and what the practical problems were. And as a practicing lawyer, I completely resound your views, particularly on the fact that, and with specific reference to the Intellectual Property Appellate Board, from 2013 to 2016, it didn't have a chairperson.
Yeah.
As you correctly said, that there were practical issues. It wasn't as if the government was delaying the matter, but people were not willing to accept, and that was well known within the.
I want to correct you. Government was not delayed.
Yes,
because of
Correct.
the cooperation between the executive and judiciary. And
Absolutely.
Judiciary was not finding a right person to place there. Already told you, people are not willing to go to Chennai and sit there. That is the main reason for
that is exactly my view also. I'm resounding what you're saying. And I agree with that. The government did not delay that. The fact was that people weren't agreeing. The judiciary wasn't able to identify. People were not saying yes. And we heard many stories about judges considering and then refusing. There were many candidates who were well known.
Yeah.
And so that created its own problem with a massive backlog of particularly very complex cases. For instance, there are patent telecom infringement litigation going on, where the validity of certain asserted patents have been challenged before the IPAB. but are not they are not even at they are not even past the notice stage, and they have not proceeded on the validity challenge. Frankly, the Section 31D hearings that were conducted in November, that was because I think practically the chairman was under a time crunch as well because of his tenure, which somehow managed to happen. But the fact is that 31D was brought into the Amendment Copyright Act in 2012, and so it took 8 long years,
Yeah.
and the losses to industry on both sides are untold. And so I completely get your point. There are some nuances, Mr. Raghavender, as you know, with your knowledge of IP as well. From a practical perspective, let us take 31D. 31D is meant for one court, one designated court to set rates for the entire industry.
Yeah.
So, do you foresee a little bit of a complication here? Because here the 31D is also subject to any commercial court across the country. Now, you don't want that one radio station go in Ahmedabad and another music company go in Calcutta, and then you have multiple commercial courts granting 31D licenses. So my question is there a plan to have specialized commercial courts dealing with these matters and a designated court? Is that feasible to have a designated court for statutory and involuntary licensing? For instance, the Marrakesh Treaty provisions, which allow for a compulsory license now, statutory license now, they will become illusory if we don't have one designated court to deal with these issues. So, is that something that will be required to be looked at?
Yeah. And as you know, Amit, before 2012 amendments to Copyright Act, the Copyright Board was there, which was only a temporary copyright board, and they used to sit whenever cases used to pile up. And there was the honorary chairman without office, and the members drawn from mostly from law secretaries of various states. And this system was removed in 2012, and permanent chairman and 3 members were created. Post of 3 members were created. But later in 2000, before this became effective in 2000, the delay happened, as you said, the same reasons for the delay, and no one was ready to come. And by the time 2017 Finance Act removed Copyright Board and replaced with the IPAB. Okay. Then now this Tribunal Reforms, Rationalisation of Conditions Service Ordinance removed IPAB, and what it says, please read the words. It says, under Section 3 of the Commercial Code Act 2015, as amended in 2018. Okay. Here, commercial court need not be a designated commercial court or a dedicated commercial court set up in a district. Just like in Delhi have 22 dedicated courts in a commercial court in district. But there is a commercial bench in more than 1 crore specified value. The cases have to be filed there. Single bench, commercial bench there. But here, the question comes, all the cases can be, it says single judge commercial bench in the High Court. That is the commercial court. For in terms of whether IPAB mentioned Copyright Act or trademark or patent or design or geographical indications now. So here, my issue is something different from yours. What I'm grappling with while implementing the reforms under enforcing contract and the ease of doing business. So, if one problem said by you, where earlier only one appellate body or a tribunal is to fix the rate for royalty rate either under the compulsory license provisions, Section 31, Section 31B, or 32 or 32B.
Correct.
Yeah, 32A.
Yes.
And even for the statutory license, 31C and 31D.
Yes.
Only IPAB is supposed to do that.
Yes.
Now that powers has been given single judge commercial bench of High Court. It means one can't go to district court. Whether it's a commercial court in Delhi or
Correct.
Ahmedabad or Nagpur or Coimbatore.
Correct.
Or Silchar.
Correct.
They have to go to single judge commercial bench in Guwahati High Court or Mumbai High Court or Chennai High Court or Delhi
Correct.
High Court. So 25 high courts have these powers now. That's what I understand reading the ordinance. Number two, then your question comes, which courts, for example, you reach Mumbai for the fixation of 31D rate. I reach Delhi for fixation of 32C rate.
Yeah.
Okay, this may happen, but not in the district courts. So, but then constitution question comes. I'm not, even though I love constitution, for me, apart from the IP laws and copyright law, the most interesting law is for me the constitution. If you see the Article 214 to 231, which give powers to constitutional body like High Court, it sets its jurisdiction. These articles of the Constitution, High Court. You know, if you read these provisions, High Court have very wide, vast jurisdiction. These are three types: original jurisdiction, appellate jurisdiction, and special jurisdiction. In original jurisdiction, you have writ jurisdiction. It can be fundamental rights or PIL. All this comes under High Court as well. So we need to see whether this jurisdiction, I'm not going to the territorial jurisdiction of the High Court. For example, Delhi jurisdiction, Delhi High Court territory is within the Delhi. Bombay High Court jurisdiction, not only in the Bombay and Maharashtra, it extended to Goa, to Dayu Daman.
Yes.
Okay, like Calcutta jurisdiction to Andamans, you know, and the Kerala High Court jurisdiction to this thing, Lakshadweep.
Yes.
But here, if a Delhi High Court fixes 31D, whether it is applicable all over India, that's what your problem.
Okay.
I'm leaving it to the constitutional expert to decide. So I have no clue whether the drafters, it's been drafted by the legislative department. They have a drafting experts. Whether they have given this thought or they have a reply to this, I have no idea.
I think there, sir, the copyright rules.
Yeah,
it will have to be amended. Unfortunately,
and the rules will amend. I mean, recently amended rules are no use because you know, they are null and void once this ordinance has come. They have to re-amend that. I'm not going to the rules. Recently amended rules.
Perhaps the rules can
clarify this. May clarify this.
Yeah.
And I'm raising another issue here. As a person who has been driving the reforms and forcing contract to improve ease of doing business ranking of India and enforcing contract. Here, you know, when I joined the Department of Justice, I come to know that despite Commercial Court Act come into existence, and commercial court cannot be constituted in the district courts of Delhi and Mumbai, where ease of doing business purview is there. You know, ease of doing business ranking, calculation, methodology pertain to only Delhi and Mumbai jurisdiction.
Yes.
Here, because of the original, you know, ordinary original jurisdiction of Delhi High Court, ordinary original jurisdiction of Mumbai High Court, the matters above 1 crore only go there. There is no district court to deal with below 1 crore matter. Commercial court cannot be set up. Those matters have to be dealt by normal civil court. Then World Bank in its methodology raised this question. Then where does the case of 3 lakh rupees a commercial dispute of 3 lakh go? Because 3 lakh rupees case can't go to High Court at Delhi, High Court Mumbai. Then literally there is no commercial court. And you can't constitute commercial court. So you will not get marks here. Then we have to rush and amend the Commercial Code Act Section 3 and introduce amendments so that dedicated commercial courts can certify in Delhi and Mumbai. And also we amended specified value of 1 crore to brought it down to 3 lakhs. 2000 amendment data. With this, do you think that 3 lakh case can go to High Court again? And World Bank may not like this? Here, you may raise this question. But still, this matter can go to, any dispute can go to, but here which matter will go to High Court single judge? Compulsory license matter, statutory license matter, and registration matter.
Correct.
Not the dispute, infringement matter. I want to clarify. Infringement matters of whether patent infringement, trademark infringement, GI or copyright with a value of 3 lakhs, how to go to this dedicated commercial court only.
Correct.
That's what I'm giving this clarification.
I think they will have to. So they will have to then look at amendments in the commercial court rules.
Yes. So one should not get confused with this. So that's what I'm clarifying. Another advantage of commercial court instead of IPAB, I tell you. For a commercial court case, before filing anything, there should be a pre-institution mediation. Again, this we introduced in the new section 12A in 2018 amendment.
Yes.
You know, this is a mandatory pre-institution mediation with the opt-out model.
Yeah, when you're not seeking,
if any party doesn't want to come voluntarily for this mediation, they can opt out. Then there will be a non-starter certificate issued. They can go for the trial and judgment arguments. Otherwise, if it is settled, and thanks to legislative department suggesting this, because India there is no standalone mediation law. Any mediation will not have legal value. Tomorrow you may renege on that agreement and go out of that agreement. To make it a law. And the provision was introduced in the 12A itself of the Commercial Court Act while introducing the pre-institution mediation mechanism, that the settlement is equivalent to arbitration award of the Section 30 of the Arbitration and Conciliation Act. So legality given to that. Only commercial court mediation, not other mediation. That's why for other mediation, we are telling the other ministries in a policy reform, please introduce the same mechanism in your laws administered by you before law ministry comes out with a comprehensive umbrella of mediation law governing all these things. This is what I'm saying. Another advantage I'm telling you, there is a case management hearing. You know, Order 9, 10, 11 of the CPC. We have to examine the documents and all that. A kind of pre-trial conference has to happen, but that never happens. Sometimes either judges don't have time or one of the lawyers try to avoid this. It's all delaying tactics. Now it is a mandatory case management hearing, and they have to fix a date, pre-trial conference. A cause list is generated through the CIS e-courts website. Automatic it is, and then you go there and then find out, fix the frame the facts, find out the list of witnesses of other party, find out the list of evidences of other party, and the date is fixed. Now it is clarified. On these matters, you are not seeking any adjournment unnecessarily. So I've not got the list, I've not got that information and all that. Documents exchange, everything is done in one conference. So lot of unnecessary time is reduced for the faster jury. And I tell you, apart from that, you can, as per the Commercial Court Act, amended CPC provisions in the Commercial Court Act, you can go for the summary trial here, summary judgment facility is there. So far, no one has exercised this. And apart from that, entire process has to be completed in 1 year, 365 days, if we follow the timeline strictly. And what we have done, we issued request. Even Law Minister Honorable Ravi Shankar Prasad himself written to Chief Justice of Delhi, Mumbai, Kolkata, Bangalore to give advisory to these commercial court benches, whether it is in High Court or a district court, dedicated court, to follow the Order 17 Rule 1, that only 3 adjournments can be given, that too only extraordinary situation of death, accident, or force majeure thing. Otherwise, cost has to be imposed. So this has been strictly followed in most of the cases. Time has come down. And number 2, the entire trial, why commercial courts have been set up on the enforcing contracts? To reduce the time taken. The average time taken in India is 1445 days. If you remove the enforcement of this order 3-5 days, 1100 days roughly. Now Delhi has brought down to 600 days. Mumbai has brought down to 200 days. I'm talking about the contested cases, Ameet.
Absolutely. There's no question about it.
And this has been in a recently held survey, lawyers has expressed this, that yes, time has reduced. I tell you one more advantage of the commercial court. Amendment to section 35A, 35 of the CPC, a winning party, for example, you have a copyright dispute, a patent dispute, under the Commercial Court Act, winning party can get the entire court fee, the cost from the losing party, as per the section 35, amended section 35 applicable to. So many advantages. So many advantages. And apart from that, technology I'm talking about. Now,
no question about it, sir. In my view, the commercial courts legislation has not only shortened and expedited litigation timelines, but to some extent, I argue that, and I've written on this, it's elevated the jurisprudence as well.
I tell you, Amit, I tell you, other technology, leveraging technology by e-courts. Other day, Honorable Justice Dr. D.Y. Chandrachud launched e-filing 3.0. It's a disruption.
Yes.
Like a lawyer, you can have a portfolio management of 100 cases in Supreme Court and High Court, and all the 25 courts orders are available at one website. Maybe 35 million orders are available. You can search by name, search by number, year, lawyer name, or any other method of searching. You can search these orders and e-filing with e-signature of the documents. That is a disruption which lawyers have been waiting for so many years. And if that is there, what we have done recently, I tell you, you may not be knowing. Our department constituted a committee to expedite e-summons. Many law commission reports said the 65% pendency in courts because of delay issuing summons. So what we have done, we entered into an agreement with the Ministry of Corporate Affairs. They have a registration of companies' data. They have email ID, telephone numbers, database. That database patchwork they have created with an API. That API they have shared with the e-courts of e-committee of the Supreme Court. That has been given to Mumbai High Court and Delhi High Court. They have put it there. Now, the moment you e-file your case in Delhi and Mumbai, all telephone number of opposition party will be fetched there. And that system, that CIS 3.2 software system will automatically issue summons to them by email with SMS alert. How much time is saved?
Fantastic.
How much time is saved?
This is, you're going to cut down, and sir, coming on this point, you are talking about intuitive technology now. In the sense that gathering data and then leveraging data. Now, in your view, what will be required? Now, consider, say they have about 25 to 3,000 cases at IPAB, which are pending. Now, those have to be obviously transferred to the various high courts.
Yes.
Are they going to transfer them on a bench by bench basis? Delhi bench comes to Delhi High Court, or are these rules still to be thought of? Or will the DPIIT, which is the nodal ministry, think of these rules or how the transfer will happen.
Yes, they have to. There are instruction by the cabinet that law ministry. Whenever you introduce the law, after introducing the law, you should not take time making the rules. So
Right.
you should be ready with the draft rules. The moment the act is passed, within a short time, rules have to come out. So, and they must be already working on that.
Yeah, so a lot more work has to be done, obviously.
How to transfer these pending cases of IBAB to concerned high courts.
Right.
That has to be done.
Wonderful.
And I'm telling you, I'm in total support of this disruptive policy initiative, amending and removing this IPAB, because there was delays in various
I
ways.
agree.
Only thing I say again and again, the judge who is going to sit there should be thoroughly trained in intellectual property rights.
Correct.
He should not be a novice or a person.
Absolutely.
I don't know what is data exclusivity. I know what is compulsory license or statutory license difference. That kind of thing should not happen.
You hit some very important points, and I particularly, want to echo your support for this ordinance, because I've seen the IPAB function over a period of time, and it's not for individuals or governments, etc. But as you said, over tribunalization has made it cumbersome and unwieldy, and nobody is able to manage. Judicial independence demands that the government keep its distance, and the judiciary does not get involved in administration. And so a lot of the tribunals and the IPAB certainly has floundered over a period of years. And I think what this ordinance and hopefully the legislation which Parliament should pass will achieve is give some sanity and logic to what intellectual property disputes or the prosecution related rate fixation, appeals against unreasonable tariffs of copyright societies, etc., are invested in specialized IP courts. And in my view, this is the emergence now of specialized IP courts.
Yes.
And we are on that road, and you put us on that road, which I'm very glad. Again, I want to add the caveat that Mr. Raghavender's views are his own individual personal views, not reflecting the government of India's views or position. As a lawyer, I'm putting it at the beginning or at the end of the discussion. I've been messaged by Lohita that we are out of time, Mr. Raghavender, but this was such a pleasure, as always, to hear from you and to get your kind of valuable inputs on this. There's a lot of practical work that has to be done. The first job has been done, the heavy lifting by the law ministry and the finance ministry, and now I think the relevant nodal ministries will have their job cut out to make sense of and channelize how this is going to work. And hopefully our specialized court system will deliver as the commercial court system has delivered to a large extent. I want to thank you, Mr. Raghavender. Thank you so much again for taking time on a Sunday that too.
No, it's my pleasure interacting with you, Amit, always. We earlier also we had a number of discussions during the copyright amendment, and various forums we used to meet on IP discussions. And thanks again to Lohita Sujit, my friend, inviting me and to be part of this thought-provoking discussions with Amit on the ordinance.
Thank you so much, Lohita, again from my side as well for having us.
Well, I'm most welcome. I'm very embarrassed.